my video on, please.
All right, welcome everybody. Thank you so much for joining us. If you'd like to introduce Partners Resource Network, please.
Yes, my name is Linda Westrick, and I am with Partners Resource Network, the PACT project. We are the Parent Training and Information Center for the state of Texas. What we do, the main thing that we do is we end up working with parents to help them understand their rights under the Individuals with Disabilities Education Act. We also help them better work with the school districts and in getting the services that their child needs. We are completely free because we are grant funded by the Department of Education, Office of Special Education Programs in Washington, D.C. We offer free trainings, free resources, free information, art support, one-on-one consultations. We can help you understand your paperwork, agency referrals, emotional support, as well as self-advocacy programs. We do have a lot of programs, including for youth, and we work with parents of children with disability and youth with disabilities from the ages of 0 to 26 throughout the state of Texas. I will periodically be putting our information, contact information into the chat box so that you will be able to have that at the end if you wish to call us. We have regional coordinators. Most of our regional coordinators, if not all, have children with disabilities themselves. So it's kind of one of those parent-to-parent things with parents helping parents that have been there, helping other parents kind of go through the process. So I'll go ahead and give it back to Michelle now and have a great webinar.
Wonderful. Thank you so much. So today's webinar, just to repeat so that everybody is aware, is being recorded. Later on today, we will email you a link to the recording and we will send you these slides. We have Boyd Handley with us today to talk about wills, probate, and planning documents that you should think about. I am Michelle Morris and I'm with Consolidated Planning Group. So we really appreciate Partners Resource Network and Boyd for helping us out today with this great webinar. So we are a financial planning firm that focuses on helping families with special needs loved ones. You know, when you have a child who might need care for the rest of their life, once you're gone, it's kind of like a third bucket of money that you need for retirement. And we're here to help with that. We're located just outside of Houston in Sugar Land, Texas, but we serve families all across Texas and all across the United States. We have over 30 years of experience in insurance and securities, and we're members of the Special Needs Planning Academy and nationally certified as Social Security advisors. Families come to us for things like protection plans, lifetime care issues, transition planning, ABLE accounts, and of course, advocacy and education. There are over 263,000 financial advisors across the United States, but fewer than 200 of those, not 200,000, just 200, focus on special needs planning. That is fewer than 0.1% of all the financial advisors in the United States who do what we do. So you are really in the right place. When people think about special needs planning, I know that what keeps you all up at night is wondering who is going to care for your child when you no longer can. And some words of advice for you on that is to start planning as early as possible. When you plan early, you're going to be able to answer those questions, or at least know where you need to go. And you won't be spending so many sleepless nights because you'll have a plan in place. We want you to think about what comes after high school. There are educational options, vocational options, and plenty of residential options for you. But all of these things might need some research from you to find the right ones for you and your family and your child. And there might be waiting lists that you need to consider once you do find the right spot. And also make careful considerations when you think, oh, my child's sibling will just take care of him. That's not always the best solution, because we want that sibling relationship to remain loving and caring and friendly and not become adversarial or resentful in any way. So just keep that in mind. We offer free consultations to anyone who wants one, and we'll talk more about that at the end of this webinar. But for today, please just put any questions or comments that you have in the chat box. I find it much easier to use than the Q&A. So please put any questions you have in the chat box. We will get to as many of those as we possibly can. And without any further word from me, I would love to welcome Boyd Handley to tell us about wills, probate, and other planning documents that you need to think about. So Boyd, I'll run the slides for you if you just let me know when to switch slides.
That'd be great. Can you turn my video on, please?
No, I don't think I can. I think that you need to.
No, it says that you've got it blocked. So
Okay. Well, that is not me. That would be Linda. If you could please make sure that Boyd could share his video, that would be great.
Okay, hold on just one second. I can't share my video either.
well, the video's
It's
fine. I just
taken
need
away from me.
for it to be
So
turned on. So
let's see.
that's okay. We'll keep going here. Thank you everyone for coming today. A lot of my next slide. Here's some of the services that I offer in my practice. We do probate, estate planning, elder law, contracts, guardianships, do a lot of work with kids with special needs. I've got a daughter who's 29. She's my wife and I have guardianship of her. So we understand everything that's needed from a personal standpoint. Next slide. Disclaimer, this is just information. No attorney privilege or contract will be done based on this information. Next. All right, why do you need a will? Well, as we all know, in our wills, we have how our assets want to be distributed. If you die without a will, then it's called, your will is going to be probated under the intestate succession laws of Texas, and the state of Texas will tell you how your property will be distributed. And the issue you come in with this is if you've got minor children under the age of 18 or a disabled child that is receiving government benefits, then that creates tremendous problems in the court. And we have to do a lot more in the court case in order to go forward with that. So it saves you money by doing a will. It allows you to give your property to your heirs, and it also allows you to, if you have a trust within your will, it allows you to give out assets over a length of time. So your children won't be getting all their assets at age 18, which is adulthood in Texas. Next. All right, there's different types of wills in Texas. You can actually have a holographic handwritten will that needs to be signed, written in your own handwriting, signed and dated by you. And if you could have 2 witnesses, that would be fantastic. If not, then we'll have 2 witnesses in the probate court to testify to your signature. Online wills, you can try those. If you've got anything other than a very simple estate, I would suggest getting an attorney to draft your will for you. We talked about the requirements for a will in Texas. You have to be over the age of 18 or be in the military, and your witnesses have to be over the age of 14. Out-of-state wills are valid in Texas as long as they as long as they were valid in the state that you had them drafted in. Next. What happens to my minor children if I die without a will? Well, the state is going to appoint a grandparent. That's who they check into first. And, we may have great parents, but some may be more capable of looking after our child than the other one. So that's one of the reasons we name successor guardians in our will. And this is for children with special needs who you have guardianship of, or minors. It works both ways. If there are no grandparents alive and you die without a will, then they're going to go to the nearest relative. So you really need to be sure that this information is taken care of. If you've got a will already, we can do a separate document naming the successor guardian. Next.
Sorry about that.
We just cover that. Keep going. All right, trust. We try to do trust within our wills. There we go. There we go.
Found it. Thank you so much. I apologize for that.
And what a trust does is takes money and basically, in most cases, keeps it out of probate. And that's one of the things that we're trying to do, is keep your assets out of probate. The trust will also allow you to say that you want your child from the age of birth to 18, pay for food, lodging, and all, medical, and all of that. Maybe getting 18 to 25, a college, a car, an apartment, 50% at age 25, and maybe 50% at age 30. So you're spacing the money out. I know I was a great kid at age 18, but if I'd gotten a big inheritance, I probably would have spent it very quickly. Your wills can be inter vivos, which are outside your will. We have a special needs trust from outside of a will. I'll cover that later. Or testamentary. The trust can be dormant within your will until you die, and then your executor springs that trust into working.
I love what you said, Boyd, about allowing even a child who is a minor to have a trust. You know, my son is 19, and although he is brilliant like everybody else's children here, I'm sure that he would use some of that money on things he doesn't really need, like maybe some classic cars or a motorcycle or something like that. So I would much rather have a trustee able to help him.
Yep, that's correct. That's correct. All right, trust, as I mentioned, it helps manage your assets for your kids. Some cases it helps to lower taxes. Trust can shield assets from SSI. Trust can keep assets, as I mentioned, assets out of probate. And the main thing is keep your child from spending their inheritance quickly. Next slide. All right, Texas is a community property state, so that has a lot to do with how your assets are distributed if you die without a will. In most situations, the spouses own 50% of the house, even though one may have bought it, as long as the house was purchased during the marriage, it's community property. If you have a house that was brought into a marriage, then that's personal property. And everything really depends on, it's almost like a divorce settlement, how everything is noted from community and separate property. Next slide. All right, this is something, we'll just go with the first one or two. If you die without a will, you're died intestate, spouse plus kids from the current marriage, as long as you won't get anything else, it's going to be divided up by 1/3 and 1/3, and the wife will get a life estate. Spouse plus kids from another marriage, big problems come into that. And if the spouse doesn't have any kids and you've got parents, then you're going to get that taken care of. So it's not as simple as you think it is if you die without a will. Next slide. And again, I've got a lot of information on these slides, and they'll be given to you at the end. So I try just to skim over the main issues in each slide. We've talked about it. Your loved one is getting what you want them to get. The trust keeps your property from going to a minor or a child with special needs. And if you don't do that, then it's going to be tied up in probate for a long time because there's a lot of different laws dealing with minor kids receiving inheritance. Next. Wills are great, but these documents are probably more important at this time in everyone's life than the wills. There's the power of attorney, allows you to appoint someone to look after your managerial and financial. And you can do it now or when you're incapacitated. So I normally tell parents, folks, if they've got elderly parents still living, be sure you have a power of attorney, a medical power of attorney on them, because if something, normally what these older parents do, they give it to each other. And if one gets dementia and one has a stroke, then you're out of luck. So the only way to go about doing that, if you're not as the successor agent, is get guardianship of your parents. And that's just crazy to have to do that. And then if your parents say, I don't want my daughter in my business, then you can say that it comes effective once a physician or one or two declares you incapacitated. So that should give them some leeway in allowing you to be on their power of attorney and all of that. HIPAA, Health Insurance Portability and Accountability Act, basically that allows you to get medical records on your loved ones. They can be digital or in paper, can't be verbal. Physician's directive, sometimes called a living will, that allows you to make decisions at your end of life. The reason I like to do this when parents have kids is that you don't want this to happen where mom told me she wanted this, and then the other sibling says, no, I think she wanted this, and then they'll never talk to each other. So this is really good for keeping your kids from arguing at your death. PLD, right of survivorship, that's basically two functions that will keep your a little bit different than everything above, but what that does is a POD on your bank accounts will allow you, if your spouse dies or someone else dies, then if you have POD naming that successor, then they automatically get that money once they turn in the death certificate. Right of survivorship, it's very similar, but it's for your homestead and other personal other property. Basically what that does is, as I mentioned, our community property estate, each spouse owns 50-50. And if one spouse dies, even with a will, and they don't have a right of survivorship on the house, then they have to go through probate. What this document does is allow you to file an affidavit of death on the deceased spouse. And then you can also file a deed getting everything over to you. So it's a lot easier to do this now than having to worry with it down the road. Next slide. Statutory power of attorney. Really want to say only two things here. In order for some of these kids that are turning 18 with disabilities, some of the parents are debating on whether partial guardianship, and I do more partial than full, or a power of attorney, a medical power of attorney is a good alternative to guardianships. The issue is that with the power of attorney and medical power of attorney, they have to have the cognitive ability to understand what they're signing. I don't do a lot of these, but when I do these for kids with special needs or disabilities, then I have them in a separate conference room, quizzing them on what they're signing or what they think they're signing. And then mom and dad will be in a different room. In the past, I've done this in the same room with mom and dad, and these kids look to the left and to the right to ask mom and dad yes or no. So really doesn't work out very good that way. Next slide. Medical power of attorney. With the power of attorney, I normally say it can be valid now or later. I always like for the medical power of attorney to be valid now. My mother-in-law was in an accident during COVID, and she was taken to the hospital. Of course, they wouldn't let my wife into the hospital. So she luckily had a valid medical power of attorney and was able to email that to the doctor, and they were able to talk to him about her mom. So extremely important. Also, if you've got kids going off to college, once these kids turn 18, they're adults. And if you don't have a medical power of attorney on them, or power of attorney in some situations, you can't call the hospital and check on them. because they have not given you the authority to do that. So extremely important with kids turning 18. Next slide. All right. We've come out in 2015, they came out with the supported decision-making agreement. It's really a gray area between the power of attorney and medical power of attorney and guardianship. And the reason I say that is that the code does not mention that the individual signing these documents will need to have the cognitive ability to understand what they're signing. So what this allows you to do is, if you don't think your child needs guardianship or partial guardianship, and he's really not able to sign a medical power of attorney or power of attorney, then you can get a supported decision-making agreement. And what this agreement does is allow you to get into meetings with the doctors, with the schools and your ARCs and all of that, and explain to your loved one what is going on. You cannot make decisions for them, but as a parent of a child with special needs, we understand how to get messages to them. So this will allow you to go into a meeting and tell your loved one what's going on. But then unfortunately, at the end of the day, he has to sign it and it's his responsibility. So it really does assist. That's the only thing it does. Next slide. The power of attorney and medical power of attorney, that's a fiduciary agreement. And what that means is that you have the legal right to take care of their interests, and you're bound by the law to do that. A supported decision-making agreement only creates a confidential relationship, which means, well, you just can't tell anybody else what's going on. But there's no legal duty for you, unlike the power of attorney and medical power of attorney, to do specific things for your loved one. Next slide. All right, probate in Texas. One on the right is when a valid will is available. You can do a regular probate of the will, which will give you letters of testamentary. I hope you're hearing me because my screen is frozen.
Yes, we can still hear you.
Right.
You paused for a moment, but you're back. So go ahead.
Fantastic. So, and then the monument of title, it's normally a will needs to be probated within 4 years of the deceased died. If it's not done in 4 years, then you can do what you call a monument of title, which will basically transfer ownership of the house or a portion of the home that's still in the estate of the deceased. Now, there's 3 other options when no wills are available. Termination of heirship. That's really when you're have a estate that needs to be probated and you need an executor. Then you would file on determination of heirship, which the court will appoint an attorney ad litem to check to see if all the heirs are accounted for. And then during the same time that we're doing that, we'll file for probate off the will too. So those 2 things run side to side. Small state affidavit, if you got no debts, assets under 50,000, then you can do that if you have a home that you want to fix with the ownership. And then affidavit of heirship, basically you're transferring real estate to the heirs, and then those who would be filed with the county clerk's office. So there's a way to get around a lot of this. Just be sure to talk to your attorney on what's best for you. Again, major issues when the heir is a minor. It's just turns into a reasonable probate to a nightmare, for lack of a better word. Next slide. Monument of title. Again, I won't go through a lot of this. but you can read this after the presentation, but it gives you some reasons why monument of title will work. We do have to go to court on this, but it's a very short probate process. And basically what you do once the judge signs an order for monument of title, then you file that with the local deed office. Next slide. Oh, probate will issue the letters, testimony, or letters of administration. This, those two documents are the legal document that will allow someone to distribute the assets of the deceased person. It gives you all the rights to do that. We do a lot of these where they might have a bank account that didn't have POD on them or something like that, or we need this in order to close those bank accounts out with that. Next slide. Determination of heirship, as I mentioned before, basically the court will appoint an attorney ad litem who will talk to the surviving family members and be sure that there's no children out of wedlock or something like that, and the ones that were named or the right heirs. Next slide. Small estate affidavit. I've only done one or two of these. You don't see these a lot. If you've got assets that do not exceed $7,500, then you can go this step. Very quick and with that. Next slide. Affidavit of heirship. We'll skip this. Okay, ways to keep estate of your deceased out of probate. There's something called a living trust. A lot of families put their home, their cars, and everything else in a living trust, and then have a trustee transfer those assets. So once the deceased is passed, and that's outside of probate, we've talked about the right of survivorship and how to use that. Beneficiary's name and life insurance on a retirement fund that will keep those assets out of probate. All the heir would have to do, in most cases, they'll call you ahead of time, is send a copy of the death certificate, and then they'll write you a check. Payable on death, that's at the bank. You go into their form and then put ever who you want to do that. I've done that with my wife for my 50% of my account, and also some of these accounts have right of survivorship, which basically passes to the deceased portion of their account, passes to the living spouse. We also have something called transfer on death deeds. You'll hear them called TODs and ladybird deeds. They're, if you have a right of survivorship with your spouse and you want the house to go to a third party at both of your deaths, then we can do this, and that keeps that house out of probate. Next slide. Oh, Todd, definitely won't go through all of this. Very busy slide, but Todd, if this one I will say is that if in doing a Todd, if an estate is near or insolvent, then if you do a Todd, there's a 2-year limit that creditors can come after the estate. So whenever you do a Todd, just keep that in mind. Next slide. Ladybird deed. This is not Ladybird Johnson. It was actually taken care of in Florida and brought over. But it's some called the enhanced life estate deeds. And this particular one does not have an anti-lapse statute such as the TOD. But what you do need to understand is in both of these, have the attorney speak to you very well on the pros and cons, because there's some weird stuff that goes on with heirs. Like if you have a TOD to your current wife and you get a divorce, then you need to change that because it does not bypass a divorce. Where a will, if you have a will with you and your spouse and you divorce your spouse, then the will assumes that she passed. So that's very helpful. Next slide.
Boyd, before we go to the next slide, we do have a quick question. Are you willing to take it now?
Oh, absolutely.
Sure. Okay. We would like to know why it's important to keep things out of probate.
Well, probate costs you money. It costs time. And if you can keep everything out of probate, it just saves you money and headaches in the future.
Okay, thank you.
Right of survivorship, we talked about that. Next slide. Property tax exemptions. If you have a trust, living trust with your homestead in that trust, be sure that you have the correct wording in that trust so you can get the homestead exemption. That's very important. There's particular wording that is needed, so especially if you bring in a trust outside of the state, you might want to talk to the lawyer if down the road a homestead may be in that trust in order to fix that, because you don't want to lose those benefits. That also happens. I know that I was recently moving a teacher's retirement fund to a trust, and I had to be sure they require specific language in the trust in order to move that over. So there's some things that you really need to be sure you talk to an attorney if you're trying to do that. Next slide. Oh, if you're a private business owner, be sure you have a succession plan. Whether it's noted in your LLC or whatever, very important. Be sure you have someone with a power of attorney that can close that account down. If you die without a will, then and you have automatic payments to that account, the bank's not going to shut it down. And the only way you can keep those keep that money from going out is to call the service vendors that you're paying on a monthly payment and tell them to stop taking it. So very important to have this noted in your business plan in case something happens to you. Next slide. Other possible problems. Don't leave money to your child's name into a will. It definitely needs to go to a trust. If you've got minor kids, don't name their name in a will. Have a contingent trust where you can dish that money out at certain ages. A lot of parents set up a 529 college account and the child still now is diagnosed with special needs and they won't be going to college. If you've got other kids, they can move that to other kids. You can move that to a ABLE account, but you can only move $17,000 a year. So just be aware of that. Grandparents also set up UTMA accounts. In Texas, money transfers to the child at age 21. If it's a big account, you probably don't want them getting that money then. So we can always move that money around. I had a situation a number of years ago where a parent died unexpectedly offshore and left his 7-year-old son a $500,000 life insurance policy. What happened with that is that the life insurance company told the surviving spouse, you can do 3 things. You can keep it here until the child turns 18 and he gets the $500,000. We can move that to a UTMA account and he gets a $500,000 at age 21, or we can put that into a court order trust, and then you can have that money distributed. If you don't want to do that, then you can also go to probate court and get guardianship of the estate off your loved one, and then you have access to that money. So a lot of issues that come up if you don't know some of these simple deals. Next. Thank you very much. This is my wife on the left and my daughter in the middle. We're, as I say, Team Handley. We do a lot of resource fairs, and I always like to take my daughter to the resource fairs and show parents that, you know, these kids can grow up and deal with their disabilities. And, you know, of course, the littlest thing we're all proud of them doing, and but we always like to show her off, so we're so proud of her. But again, presentation will be sent to you. If you have any questions, please call and email me. Thank you so much for your time.
There is one more question, Boyd.
Okay.
It says, just to confirm, if a grandparent is mentioning a grandchild with special needs in their will, they need to address the trust in place for them, right?
That's correct. It should go to the contingent or the special needs trust for the benefit of that child. They should never name the name. Now, we can always go to probate court and fix stuff like that. But then again, it's very easy to do that, a lot cheaper now than later.
Wonderful. And if you have more questions for Boyd that you would like answered right now, please put them in the chat box. I have a couple more slides to go through. And then once I'm finished with my slides, I'll get to the rest of the questions for Boyd. So you'll have all of his contact information here on these slides when you receive them later on today. Thank you so much, Boyd, for all the fantastic information that you've shared today. These are some of the other webinar topics that we sometimes cover. We do webinars several times a week, and we cover things like special needs care plans, the future care cost estimates. You know, what does it look like to be able to pay for a residential community in the future, or maybe a group home, or whatever your situation may be or may require in the future. We can help people with the Texas waivers and the interest lists. You know, I was recently told that instead of 15 to 17 years, we need to be saying that those waiting lists can be 20 to 25 years long. So it's very important that you get on the waiting list for those waiver programs as early as possible. We help people understand SSI and SSDI, what the differences are in those programs and how they work. ABLE accounts, why you need one, why you need an ABLE account and a trust, how those two things are different and how they work together. Beneficiary designations, as Boyd was mentioning, never ever do you want to leave something straight to your child with a disability, because that will cause them to miss out on some of the benefits that they deserve. So you want that money to go to a trust, a special needs trust for your child. There are two different kinds, a first party and a third party. And I see somebody in the comments would like for us to explain the differences between a first party and a third party trust. Boyd, would you like to take that one?
Yeah, that's fine. A third party special needs trust is just like it says. It's assets and money from the third party that they are giving to the beneficiary. In my situation, we have a third party trust for my daughter. It has some money in it that my parents gave her, and then I haven't funded mine yet. Mine will be funded at my death. Of course, I've got everything going to my wife first, and then if we both die in an accident, then everything goes to my daughter's third party trust. A first party trust is money that belongs to the beneficiary. That can be a court settlement, that can be wages that they earn by working, or it can be anything else, maybe a overpayment of SSI. And you can put that into a third party trust and first party trust, and that will protect it from counting as assets with SSI. The only issue with a first party trust, a ABLE account, and there's something else called the Texas Pool Trust, is that those have Medicaid payback, you know. And what that means is once these kids turn 55, then if they're still getting Medicaid and they pass, then SSI can come back, or Medicaid can come back and get the money that they had given your loved one through those three financial compartments.
Thank you so much. So when you get these slides, this link here with the upcoming webinars will be clickable for you. So you'll be able to check out our schedule of what webinars we have coming up. Just want to introduce our fantastic team. It's actually two pairs of husband and wife. So Allison and her husband, Jeff, are the owners of the company and the financial advisors. And then there's my glamour shot and my bearded husband, Andy. We are the other two financial advisors with the firm, with Consolidated Planning Group. And then we have a wonderful support staff who will be reaching out to you to see if you would like to schedule a consultation. During these consultations, we get to know a little bit about you and your family and answer the questions you have. And then we'll tell you about us and how we work and what we charge and things like that. This page also features the links to our YouTube channel where we put all of our webinars after they've happened, our Instagram page, our podcast, which is relatively new, but we do put our webinars on the podcast as well. So if you're listening on the podcast and you would like a copy of the slides, you can email us contact@cpgcares.net, and of course our Facebook page. So Boyd, about how much does it cost to draw up a will and a special needs trust?
It really depends on the attorney that you're using. They can be as low as $500 for a simple will, and it increases depending on if you have a trust in the will, and then whether you're doing a trust for both spouses. Okay.
And how often would you suggest that people update their wills? Like if they buy another house and they want to add that in, or do they have to do that?
No, excuse me. No, I just suggest doing a right of survivorship on their new house, then they won't even have to worry about the will.
Okay, great. And then people should update their wills, what, maybe every 3 to 5 years, have someone look at it, or is that
I'll have
too-
someone look at it. I mean, I don't do a lot of updates to wills. If we do need to update the will, we can do a codicil, which is a attachment to the will, changing particular wording within the will, and we can do that.
Wonderful. We have a question out there. This one is for me, a brief explanation on the difference between an ABLE account and a trust. And then someone else asked if you can transfer the ABLE account into the trust. So we've done entire webinars about ABLE accounts and trusts, but really quickly, the main difference and the reason that you need both is because with the trust, you can put in as much money as you would like, but there are limits to what you can use that money for. For example, you should not use the special needs trust to pay for food and shelter and to get cash and things like that. The ABLE account, on the other hand, there are limits to how much you can put in. It's $17,000 a year, or whatever the gift tax limit is for that year. And then you can put in additional money if your child is working. That's $13,590. Now, you never want your ABLE account to go above $100,000 total in that account, or else it will affect your benefits. So there's a limit on how much you can put in, but as long as you use that money to achieve a better life experience for your loved one, that's what ABLE stands for, achieving a better life experience, you can use the ABLE to pay for it. It could be a car, a computer, college courses, housing, food, a laptop, a phone, a vacation. You know, you can even pay for the vacation for a caregiver or two, not the whole family, but a caregiver or two. So there's different limits on each, the special needs trust and the ABLE account, and they work well together because you can use them to pay for different things and transfer money kind of back and forth with them. You have to be careful though, because with the ABLE account, once you have money in there, You can't just roll it over to another child. It has to be another child who qualifies by having a disability. It can't be rolled over to just anybody. Is a living trust better than a will? Can a special needs trust be part of the living trust? Boyd, that's one for you.
Yeah, well, the living trust, it really depends on what you want to do. If you have assets that you don't want people seeing, with the will is public knowledge, then you can roll it over to a living trust. If you're young and buying houses, we'll be buying 4 or 5 different houses between now and when you die. It's probably not worthwhile having a living trust because you've got to move with a deed, move the house into the trust, and then the trust actually sells the house when you're getting rid of it. But it's really, I think, with a living trust, it depends on what the situation is, and also you can have a special needs trust mentioned in their living trust. So.
Wonderful. Well, that's the last question that I see out there. So I just want to thank everybody for taking the time to be with us today. Boyd, for your great presentation, and to Partners Resource Network for hosting and sharing the information about us with their families. Please schedule your free consultation, and be aware that we will be reaching out. So please be kind when we do call you to see if you have any questions. We're here for you. We're here to help. And we truly appreciate you being with us today.
Thank you, everyone, for attending. Also, you're welcome to reach out if you have any questions about other things with special needs and education and then that type of thing to Partners Resource Network. I did put our contact information in the chat box a couple of times, and I will add it once more before we leave. So please, everyone, let us know if you need anything. And I really appreciate everyone for being here. And I appreciate Consolidated Planning Group. Love having these webinars with them at least once a month. And I know we have others with other regions as well that are part of Partners Resource Network. We do cover the entire state of Texas in one form or another. So just feel free to reach out to us. And thank you, Michelle.
Wonderful. Thanks a lot, everybody. We'll talk soon. Bye-bye.
Bye-bye.